Hello, everybody. I'm Dr. James Burney, patent attorney here at Phillips Allman Fitzpatrick. In a previous life, I was a research scientist in both academia and industry. My background is medicinal chemistry and organic chemistry. My patent practice now focuses mostly on small molecules, organic and biological chemistry. As part of my practice, I've been involved in appealing several examination reports before the New Zealand Patent Office. And as part of our snapshot series, I'm going to have a look at some of the basics of law and practice in this jurisdiction, including how best to go about examining and prosecuting your patents, some divisional practice tips and traps, patentable subject matter, and a quick look at appealing examination decisions at the end. Before we start on the substantive questions of law and practice, a question I always get asked is, why would I file a patent in New Zealand? And particularly that's because it's a small population, and is that going to justify the cost? And the follow-up is always, I've heard it's tricky to prosecute patents there. So that's the kind of negative side of it. The positives are that there are strong export sectors in agricultural, livestock, advanced manufacturing, medicinal inventions, and metal refining. There's a centralized healthcare system and it's a developed economy. So for things like pharmaceutical science and medicinal medical devices, there's quite a strong impetus to file a patent there. Should you ever come to enforce your patent in this jurisdiction, there's also a respectable legal system. So there's quite well-developed recourse if you wish to enforce. So I guess now it's time to move on to what I would call an unfair reputation for this being a tricky place to prosecute patents. I think the New Zealand Patent Office would argue they are more thorough than some other jurisdictions. So before we get on to that, it's important to note that there's a trans-Tasman IP regime in place between Australia and New Zealand. So as an Australian qualified patent attorney, I'm also qualified to act before the New Zealand Patent Office as well. For those not in the know, I've highlighted the Tasman Sea here. It's colloquially known as the Ditch and was discovered by Dutch navigator Abel Tasman many years ago and is known for its particularly rough seas and diverse wildlife. Now, despite having some similarities between law and practice between Australia and New Zealand, there are significant areas of distinction that can lead to some difficulties without due guidance. So let's have a look at some basics. So New Zealand is the 31st country to enter via the PCT route, similar to Australia. If any amendments are made during the international phase, such as Chapter 2 examination or Article 19 amendments, those in practice have to be incorporated by patent attorneys when you enter national phase. Now, there's a 5-year examination request deadline, and that date is calculated from the date of complete filing, which is the PCT filing date or Paris Convention filing date. In some cases, the Patent Office will issue a direction, and we have two months to request examination from that date. But it does not always happen, and it has some very important implications for divisional practice we'll talk about later. However, once an examination report has issued, there are 2 important deadlines. The first is you have 12 months to obtain acceptance and overcome all objections in the report. And there are response deadlines in New Zealand, the first one being the 6-month deadline, which typically shortens to about 3 months after the first response has been filed. There is a 1-month extension available to file a substantive response, but a bona fide attempt must be made to address all objections in the report. So filing a stopgap response during the extended period is certainly something you don't want to be considering doing. Claim fees are calculated over 29 in groups of 5, as based on those that are actually examined. The fee is not particularly high and multiple claim dependencies are allowable. So this is something you don't really need to worry about, in my opinion. Some other general information is that there's no IDS requirement in this country. Third-party challenges can be made pre and post-grant. There's no pharmaceutical term extension provisions available yet in this country. And extensions are available for late national phase entry in exceptional circumstances. We have had success in obtaining extensions to international phase, for example, for many months, but that's highly dependent on the factual scenario that can be made out. But it is something you can consider if national phase entry has been missed. So the New Zealand Patent Office new act, as it's still referred to, is actually quite old now. There isn't an awful lot of judicial guidance or authoritative guidance to go off from the Patent Office nor the court. The knock-on effect of this is that New Zealand examiners often look elsewhere where the local law is underdeveloped, especially Australia because of the Trans-Tasman Agreement, but probably more so the UK and European case law. This causes quite a lot of friction because, for example, the test for inventive step in New Zealand is distinguished from that as understood in Australia the US and under the European Patent Convention. Additionally, the support and disclosure requirements, despite being quite similarly worded to both Europe and Australia, are often applied quite a bit more strictly in this country. So experienced patent attorney guidance is necessary, and simply conforming the claims you've had granted elsewhere is unlikely to carry a lot of weight with local examiners. New Zealand is a member of the GPPH, but does not have a bilateral treaty with the European Patent Office, and using the GPPH will absolutely expedite examination times, but it won't necessarily streamline the course of examination. There is a grace period that's been recently introduced for disclosures made on or after the 30th of December 2018, but it's worth checking with your attorney, of course, if you wish to make use of excluding certain disclosures from the prior art base. We always request a deferment of acceptance because the divisional can only be filed before acceptance for an application. As I've just said, the 5-year examination deadline is very important and applies to any divisional application which can lead to an issue in New Zealand. Now, this is particularly because the New Zealand Patent Office helpfully publishes examination times, but as you've noticed, as I've highlighted on the slide here, it can take up to about 3 years for chemistry and biotech applications to be examined. So if you wait for several years before requesting examination, by the time you get a report, you could be out of time to file a divisional should you need to, or should that be part of your original strategy. This has become sort of known as the divisional trap. It's something worth reminding and reminding of yourself, and our recommendations to address this are for the biotech and chemistry space, we would always recommend filing a request for examination at the time of national phase entry. So this would give you 3 years for a report to issue, a year to obtain acceptance, and then a year or so buffer to continue prosecution in a divisional if necessary. And as I've said earlier, this is quite a strict office, especially on support and inventive step, and can go beyond several other major jurisdictions. So you may be encountering objections you've not really had to deal with before overseas. For non-chemistry and biotech applications, it's worth docketing a year or two after filing to request examination. And if, for example, you do know that a divisional application is part of your overall strategy, you should consider filing any divisional at the time of requesting examination. So for chemistry and biotech, that's when an application is filed, or for any of the other sort of subject matters, that's at the time of requesting examination, not later than a year or so after filing. If you do run out of time during prosecution, there are some ways to continue prosecution, and we'll touch on that at the end of this little snapshot. Just a quick word on amendments. They can be made at any time, but are more limited after a patent is accepted. The voluntary amendment is due if an amendment is made not in response to a specific objection. We often have to state in our response whether the amendment is voluntary or not. The voluntary amendment fee is not particularly expensive. We also have to identify a statement of support for each amendment. In practice, if an examiner has to sort of go looking for support in the specification, you can expect a further report to issue. So it's best practice to really identify textual support for any amendments to the claims. If an amendment is considered to add matter, it can result in post-dating of the specification. So unfortunately, claims are not allowed to have split priority, and this can be a real issue that you have to pay close attention to. And intermediate generalizations can be a real issue for making amendments to the claims. The subject matter that's not sort of clearly and unambiguously disclosed in the application can cause real issues, and that's lifted straight out of the Bonsall test from UK law. So it's something worth keeping in mind when deciding how you might want to amend any claims. Just a real quick flick through patentable subject matter. Computer implemented inventions are not patentable if novelty resides solely in the computer program itself, but a computer program interacting with something outside of itself in a new way is typically patentable subject matter. The position of law is relatively clear on this in New Zealand, which is quite distinguished from how it works in Australia. Cells pertaining to human beings that can develop into human beings are prohibited subject matter, so totipotent stem cells. This can be avoided by exclusion to multi or pluripotent stem cells, which do not have that ability. And biological processes for cloning is also prohibited subject matter. Diagnostic methods. So any diagnostic method that can be practiced on a human being is not a patentable invention. We typically try to convert claims to ex vivo if they're supported and if it's possible. which is not always the case, but is quite often a way of getting around that objection. Now, methods of treatment on human beings by surgery or therapy is not understood to be a patentable invention under local practice. So obviously animals are not included within that understanding. So a method of treatment acting upon an animal is allowable. The understanding of what is meant by treatment refers to an illness or a medical condition. So in some cases, for example, cosmetic treatments may be allowable, and it's all very dependent on exactly the wording and the arguments that can be crafted. So this is something that you really need expert patent attorney advice. Now, Swiss style claims are allowable for first and further medical uses, and we can sometimes convert method of treatment claims into a Swiss style claim. A word of caution, as the New Zealand Patent Office has taken a rather strict stance as to where the novelty can reside in a strict new indication or not. And again, this is something that has been subject to several hearings that I've been involved in, and is something that you'll need expert guidance from your patent attorney as to whether or not that may be allowable. As I said, I just wanted to touch quickly as an end on appealing examination decisions in New Zealand. If you do run out of time during prosecution, or indeed if you reach an impasse with an examiner, you can request to be heard. There are 3 ways to be heard, essentially. By re-examination of the documents filed. That, in my sort of advice for that, would be if there's been any serious misapplication of law. And you could also request to be heard by written submissions, or indeed to put your case in person, which we have done so when an impasse has been reached by an examiner, or if an examination report issues with very little time left with which to prosecute your application. Now, the hearing is conducted by an assistant commissioner, which is the more senior examiner, so you sort of get fresh eyes on your submissions. New Zealand hearings will take into account foreign file wrappers and the prosecution documents. There's no formal estoppel provisions in New Zealand, but you do need to be aware of the state of play of applications elsewhere. Some additional comments on appealing examination decisions is that the rules of evidence are quite strict in New Zealand and may have a bearing on any subsequent appeal of an adverse decision to the High Court, which is your next port of call. Amendments can be presented for consideration at the hearing, but it's not similar to filing multiple auxiliary claim sets as you might do in Europe. If you're pretty certain you're happy to make an amendment, I would be basing my submissions solely around your amended claim set. And engaging counsel can be something like a barrister can be helpful, especially if you're going to be heard in person. And we're often given 20 working days to put the application in order post-hearing, or indeed request appeal to the High Court. So I guess in summary, if you are in the biotech chem space like myself, you want to request examination at filing and file any divisionals. If you're in any of the other sort of technology areas, be wary of the 5-year divisional application deadline. Be prepared for strict examination, and that conforming the claims to the US or Europe is no guarantee of success in New Zealand, and any adverse decisions can be appealed by way of a hearing. So that's my snapshot of New Zealand. Thank you for listening. If you would like to contact me, please do, and ask for any more information you may need. Thank you.